Hey everybody. I don't know what happened to my what happened to my intro. I had Cresha already, but they haven't started. But while we're waiting, if y'all don't mind waiting, we've got a song. I don't have the I didn't upload the we can watch some of that walk the dog video that one of our subs made for us. I want to say, what was the name of it? It's made by lyrics by J.W. Smith, and it's a walk the dog. And I could just share it. Oh, poo.
Corey was in big trouble. She had to have 4 meals. She needed it on the double. She was desperate enough to kill. She came up with a plan. She'd buy some fentanyl and slip it to her man. Then she'd have it all.
Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny.
She put some in his sandwich, but Eric was tough. It only made him sick. She hadn't put in enough. She went out and bought more, enough to kill at least 5 men. She put it in his Moscow mule and waited for his life to end.
Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny.
She booked a trip to an island resort with her secret lover. She'd done the perfect crime she thought no one would discover. To help with the children's grief, she had someone write a book to give them some relief for their dad's life she took.
Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny.
Eric's family vowed to take this bitch down. She couldn't kill their brother, get rich and skip town. All this time the police were on to this black widow wife. They finally charged her for taking Eric's life.
They're on to you now, Corey. They know what you have done. Nowhere to hide now, Corey. Nowhere that you can run.
While she was in jail, waiting for her trial, she came up with a scheme. It was so twisted and vile. She called it Walk the Dog. Even the title sounded funky. She'd get her brother to lie and say Eric was a junkie. They're on to you now, Corey.
They know what you have done.
Nowhere to hide now, Corey.
Nowhere that you can run.
The guards searched her cell and found her little letter. They gave it to the prosecution. The evidence just kept getting better. Her own lawyer dropped her. Was it for her lies or no money? Shortly after Walk the Dog, the coincidence seems funny.
Walk that dog, Corey. Suck your brother in. They found your letter, Corey. No way that you can win.
She can't put it off any longer. Her trial is finally here. The jury will see the evidence that to us is crystal clear. She's now on trial for murder and other things that were charged. No more spending Eric's money. No more living large.
Walk that dog, Corey. Suck your brother in. They found your letter, Corey. No way that you can win.
Soon it will be up to the jury to get justice for this dark soul. It won't bring Eric back. It won't make his family whole. When the verdict says guilty, Corey will never again be free. That bitch can walk the dog straight to the penitentiary.
Go on to prison, Corey. You don't deserve another day. You killed a good man, Corey, and
Wow, that was great, J.W. Smith. That was great. There's two more of them. I'm not sure if it's. I loved it. I loved it. Anyways, we'll play the other ones too, but gosh, that's so good. I usually am way against those kinds of things, but that was really good. I'm against those kind of things. I dated a musician. I know they hate that stuff. Okay, okay. Let's see. Oh, let me find the right thing I'm supposed to be looking at. So we're going to be using this one until the other one starts. How is everything? Yikes. Very exciting. Very exciting. So, let me get this one down. So we're here for the jury instruction. They're going to discuss jury instructions today. And I'm going to mark one of these things over here. How about this one? There you go. And y'all just be watching this one right here while I see if KUTV is about ready with theirs. Okay, they are. Get rid of my CNN and my other little local things here, and so y'all, welcome to Difficult Research. This is Cresh's channel, and she'll probably be in later, and we're here for her. We support her with this channel, and we're here to get justice. This particular week, we're here to get justice for Eric Richins. I'm hearing something in there. I'm not sure if I should be hearing it. But we're here for Eric Richins this week. And we expected this to be a much longer trial. I'm not sure why Corey decided not to even put on a defense. I guess maybe their defense would, she was afraid they would bring out something else. I'm not real sure. Saves us some time though, doesn't it? Okay, let's see. I'll pick another one of these things here to... We have a lot of these banner things. And they don't all have to do with with Eric and Corey. Disclaimers of this, that, and the other. Okay. Corey Richins. And she wrote a book about grief for children after her husband died. Let's see what y'all are doing over here. I guess let me put myself right here. So we'll hear them when they start. Oh boy, I'm missing the good comments over here. Sigma Shadow 6 says, good afternoon, Crush and Sis chat. It was a rough week with illness on top of other chronic issues. Had the trial on in the background. Going to join you guys today while running errands. Well, I'm glad you're feeling a little better. Sigma Shadow 6. Gresha had been sick too. My brother and them have the COVID again. Just me said I can't stand this, which reminds me too much of Lori. She does, don't she? Just me says butter would melt in her mouth. She's so cold. That's funny. Love Always True says, I love these songs. They're awesome. We're talking about, listen, that was a good song, wasn't it? Just Me says, spot on. Okay, Love, that's a long one. Love Always True says, it's concerning how many people are defending Corey, saying that she's not guilty, that the prosecution hasn't proven the case. Can't imagine how terrifying for the Richins family if she's, exactly. Can you imagine how scared they would be to let her keep the kids? Good heavens. Good heavens. Let me make sure I haven't messed around and turned it off or don't have it live or any of those things. I'll probably have to turn the sound up when they start. I'm pretty far away from it though. Y'all just, I bump around so much I know y'all hear stuff. Maybe that'll be a little better for me to sound. Okay. Yeah, our friend JW, that was something else. That was really a good song. I gotta get rid of this banner here up here. There. I hear sirens. Sigma Shadow 6 says, the reality is that the true crime community, trial watchers, we are spoiled with the high profile cases. In all reality, not many cases go to trial, and not all cases that go to trial mount a defense. That's true. We are spoiled to that, and you're correct. I know I was listening to a little bit of the court case. It's about the Charlie Kirk murder and Tyler Robinson. And today they were arguing. I didn't see Tyler Robinson. He could have been in there, but they were arguing about whether they were going to have cameras or not, and about how much putting, a gag on some of the evidence because of getting a fair trial, was that kind of argument. And I really don't know what they came to, but they will meet back on April 17th. And maybe we can cover that one too. And Miss Nestor was not there, so it must have been somebody else from that same team. But they just, like I said, because they were arguing about the cameras, they showed a lot of backs of people's heads and not much of fronts of people's heads. Well, y'all gonna cause me to start singing that Judge Your Honor song. And I still can't say his name correctly. Okay. I don't know where that came from, but I just saw a thing saying that they have found additional images from some cameras in the case of Nancy Guthrie. about an hour ago, so we'll be getting some new stuff, I guess, about that. Come on, Nate. It looks like the last thing he would put on here was that we would be meeting at 1 p.m. today, and it's 1:17 so p.m. So they need to get on with it. Bring your head over here under this thing, Judge. So, I think we all, and I must say, until they find her guilty, we have to say allegedly and all that since, but I mean, we all know. Oh goodness, I've actually turned us off. Y'all be sure and put it on the live chat. Love Always True says, to me, if you don't have any defense at all, or anyone that will come up on the stand and speak for you, that screams guilty. I mean, you don't have anybody to say, she was a nice lady. Love Always True says, I don't understand why federal trials don't have cameras. I would love to watch one of those. Yeah, I'm disappointed too when they don't have cameras. I see they're wiggling around a little bit. I make sure I'm on live, make sure I've got this. These little devils. Love Always True says every single person that was her friend, she ruined the relationship, burned the bridges, stole money from them. She just used people. Yeah. Cigna Shadow defenses, if they put on a defense, they really ran the risk of opening the door that they really do not want the state to walk through. Part of it was addressed yesterday morning in the hearing. I got that. I saw that too. Oh, here it is. It's just Robbie says, hello everyone. Sorry I've been away to get all this out of storage and finish my robot fleet. Woo! Miss Mojo says, afternoon ladies and gents. It's just Robbie says, making progress though, and we'll be able to focus on a project in time for difficult research soon. Yay! I'm glad to hear that too. I'm not trying not to have too many windows open. Y'all, my son is working on Grok today. Or not Grok, but the Grok building. In Memphis, I guess they're having to work on their garage doors, security doors or something, but he had to get his, make sure he had his ID, all that. I'm going to be nosy and ask him about it when he gets home. I hope it's cool. I said, tell me if it smells like poison up there. So Nathaniel, Friday the 13th, y'all. Man. I would hate to know that I had to, I don't even believe in stuff like that, really. Knock on wood. I think knock on wood, I say that and do it. I don't really know if I believe it or not, but what doesn't hurt. Well, since it's super high security, they may not let him. I know I want to go up there and take pictures of the place, but I know I can only get so close to it, and I'm sure if he takes me some pictures, he'd get in trouble, so. Well, I guess we had another room for another one of them walking the dog songs. Devils. 1896. I was just thinking too, I'm always thinking about something crazy. But you know, we talk about the founding fathers and the United States of America. But when the United States of America was the United States of America, it was only 13 colonies that later became states along the coast of the East Coast. And that was the United States of America. And if you look at it, the farther it went west, the bigger the pieces became. I know New York and Pennsylvania are pretty big, but boy, those New England states are tiny, aren't they? I love that walking dog song too. Brutus, what are you doing? I heard him jump out of the bed. Then he'll go get in trouble someplace. Sigma Shadow 6 says Brad Bloodworth is incredibly precise prosecutor. His style may not be favored by many, but it is clear that he has accounted for many of the possibilities that could arise in the trial. No defense. I got that. Yep. Yeah, because it looked like to me that they were fixing to. She might get some dang drug charges if they brought in some of the people. I mean, for God's sake. Sometimes. Oh, I forgot we can do this. Well, I thought I would be quiet and they would start, but thus no. Sunshine says this trial was shorter than I thought it would be. I wondered how long the jury will deliberate. I bet it won't be but a while, just a little while. Love always. Truth says I've relived that we do not have to listen to the defense. I'm so tired of her. I've been changed the name to dance instead of defense. That's pretty funny. Come on, feller. Come on, feller. Woo! How about that? I didn't know what that was, but I thought I would try it out. I'm trying out all the stuff. Crush's not here to keep me from doing it. I'm pushing all the buttons. Yeah, the minimal one is nice. What was the block one?
500139. State of Utah versus Corey Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Corey Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all, yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, not in
Okay.
general.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No.
Oh, good.
I'll start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay. Pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial beginning. Take a moment. Take
No
us a minute.
objection from the state.
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little a little editing to remove some unneeded syntax. So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right?
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction,
From the 10th Circuit,
Right.
yes,
state, yeah,
Garcia
right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as for Crozier. So that all is great for argument, but I don't know that we need any special instruction, given
Okay.
that neither person was in custody at the time of testifying.
Ms. Nestor,
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in-custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody, if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity. I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber, it should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay,
Well,
In fact,
one-
we saw
one-
an interview
yeah.
with him in custody, in
Right.
stripes.
same with Carmen Lauber, right? Yeah,
Yes.
okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction
Okay.
as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right, it is occurring to me, if the concern is, there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved, that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but,
Yeah.
That one may be closer to the facts of this case, than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah, okay. We'll come back to that. We have
Okay.
time. Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry, which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep, I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right, and then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that, that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay, I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection and argument is based on State versus Wall, 566 P. 3rd 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah Appellate Court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes, thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30,
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But,
Do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason, and when I instructed the jury in real time, the reason I gave them was motive. Was you weren't, was it also go to
Can it go
preparation?
to identity, preparation,
I know it
intent?
can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice, we, argued for the admission based on motive, intent, plan, and preparation and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm gonna tell them that they can consider them for those specifics, there's gotta be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan, okay.
Yeah.
Yes, sir.
Okay. Ms. Nestor.
Well, I think the core was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct, so I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it. Okay, 32, 33, 34, 35, 32 through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural, many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do. Okay, 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Corey Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example. So go to page, for example, page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing about a motive at all,
Right.
just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain
Right.
is a why, not a how, and why is motive.
Right, that's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that,
But,
Because
I
then we
mean,
don't
it's-
have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So
you-
I'm okay
yeah.
with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean
Right.
without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction?
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Your Honor, I think that was part of the stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt
Yeah,
the same as yours
that was added by the court before I ever
before you
got a
did this?
chance to ask him to include it. It appears to be the same thing, so.
Okay, just one moment, Your Honor, can I just compare something just very quickly on the
Yeah,
attempt?
we'll we'll need to take a break, so put a pin in it if you want. And
It just will take me
Okay.
1 second. right, so we can just toss this, right, Mr. Burmester? We can
Yes,
throw this
yes,
out.
absolutely,
Okay,
that is,
all right. No objection to the rest of the definitions instruction, Your Honor,
Okay,
or to number 40, which comes after it.
thank you. Mr. Brimmer, is there any objection to page 40?
no,
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. But I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out, it's my reading of this statute and the information that in order to convict Corey Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury's confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included, or I mean, you could certainly argue to the jury some
That's-
factual inference that,
Yeah.
listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
That line of reasoning or doubt.
So,
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
so I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well,
Even
here,
if-
I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark, so,
Imagine a healthcare provider
right.
says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's
there's an
still
intent to
aggravating.
commit, that's an intent to commit, cause
To
a death,
cause the
though.
death, yeah.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they've put that testimony
Yeah,
down,
but that's a
right?
different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes,
Okay.
yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Corey Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together,
Yeah.
you know, we've split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death. Intent to cause a result, that's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree
Yeah.
with that.
I think we're all agreeing.
I agree with that.
Okay, can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Muji typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Muji committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law, that is correct.
Yes.
You're right, because I was gonna say, I thought we did this, but you're right, we put it in a separate instruction. This is much better to put it in the element of instruction, I think. I like it better.
With all, I mean, let's be clear, this was Melanie's idea.
Yay, Melanie.
Yeah.
Yeah.
So we're talking about the top.
So you've got,
One with A and B,
you got
right?
two options here, right? You have the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see, in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
at in the first sentence.
Yep, the reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I
Yeah.
also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Or just put a S in a parentheses, like, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that
Yeah.
sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here. Okay, no, that's fine, Your Honor.
Okay. I will make similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is or homicide's one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right, because
The mental states definition on page 46.
right, I think initially, the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know, I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state defined counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions, I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So you're gonna move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just one second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. All right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So, I gotta pull the information, we gotta look at the statute. Bear with me for one moment. Melanie, I'm not ignoring you. All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76, 6, 521,
D.
2D, right?
Yes.
All right, so let's start with a couple of my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or
But it's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing, because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then, Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right, so I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521 2D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute. There's something going on here. All right.
Excuse me.
Okay, there you go. All right, just a minute, Your Honor. 76 -6 Here it is. Okay, I'm with you. Please continue.
All right, so 521-2, an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain two categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to two alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be like, to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not anything to do with Ms. Richins. I think they liked the second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that go, I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime, they got to prove it as it's written, and they just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular Because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this, and I actually think they charge the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
No,
it doesn't
I
make
wouldn't take those
sense.
out.
No,
Yeah.
I'm saying for
Yeah.
purposes of trying to understand it in context, right? So like, the initial part of this says, intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that, or anything of value, goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker, or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's gonna just have to figure it out, but
Okay, but even in your world, in your view,
yes.
I hear you saying it would be 1, Corey Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devise the scheme or artifice to obtain
Fees for professional services.
3A, fees for professional services, comma, or 3B,
But that's-
anything of
That's not
value.
That's not how it's written, though, Your Honor.
It's exactly how it's written. I
No,
just
it's-
put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take the 1, 2, and 3 out as well.
Take the, which one?
Never mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're gonna add the theory that we're not proceeding under, then it should be A and B, to make it clear, because it is an alternative, it's a list of 2.
Yeah.
It's-
I don't know how to read it any other way.
If that's wrong, it comes back, though, because that's not, these go straight to elements.
Okay. So, Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
Your Honor,
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 766521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester?
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
on
page
count 3.
47.
I'm sorry, I gotta go back. Just 1 minute. I thought we were on 4. Okay, element Oh, took a substantial step? That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And wait a minute. Count 3. This is a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor. Oh, no, I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think it did. I can go back to what you emailed, or from the parties and was represented as, but it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted
Oh, I
those.
know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521 2D would be the devising the scheme, which I think is Ms. Nestor's point of,
Right.
well, if you devise it
I could think of one
and
right
never
now.
say anything, or
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those,
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
filing of the application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing it.
filing the claim as well, but yeah.
Okay, sure, yeah. You could, we could instruct the jury that the state's theory is that Corey Richins committed this crime by A, B, and C. I give it,
Or-
yeah, right, yeah. We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. but it seems that we don't need to be coy. We can just tell the jury what the state thinks, and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4, just read through that for me for a moment. Let me know if anything sticks out.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay? Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection, sorry.
That's okay. So then let's look at elements of forgery, count 5. 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richins' name allegedly to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. Got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
Okay. But then, I think if I understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right. And that's based, I cited the case law on that, State versus Gonzalez, State versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor, yeah, that's an
Okay.
element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
that we
just the
have
way it goes?
Authentication.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yep, because I thought execute meant make it effective, like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing, or just make a
I think it's
writing.
make or utter.
Yes.
Make
Yeah,
or
that's what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At
it
the time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that it is 50, but it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count one and then pivot to saying you can consider the strength of the evidence regarding count one as part of your consideration of count two.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it, we're just gonna click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was
Okay.
kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just two.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections.
Yeah,
Okay.
one section for each count charged. Any objection, Mr. Burmester?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says two. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor?
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think, I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I
just-
agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay, did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury, I need a place to start to
Okay.
apply gentle pressure to keep working, and this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yep. Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break. But
Okay.
let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were jurors answering it to make sure that it flows correctly.
Okay, give me just one second, Anna, I'm sorry.
Your Honor, I don't, well, unless it's at the beginning. I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now. Just
That is entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
Let me
I
forward
can
it.
maybe just
Okay.
resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it.
say skip to count two.
Or and take out 1B. And so this has to change to right there. Two. So I'm gonna take out 2B. Okay. Okay.
Concern go ahead.
Oh, if we include it. Okay. So let's see, let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count two. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count two, similar changes.
right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry, are you under 1A?
Yes, sir.
Okay,
So let's say they checked both.
so rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay,
That would be, that takes care of my concern. Because my worry would be they would mark them both and we would never know that they were unanimous on each,
okay,
or if they split it half and half. Does that make sense?
yep.
Okay.
Any
No,
objection,
that's-
Mr. Burmester?
No,
Mr. Ramos, my apologies, go ahead.
No, I apologize, Judge. I jumped the gun a little. Just for flow sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count two, and then
Sure,
after that.
that's fine.
Actually, that does make more sense.
no objection from the state.
Got it?
Same on,
Remains consistent with the,
and same under
Earlier
count
question.
two as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you've submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins
Right.
language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think
Oh,
it's
okay.
a problem anymore.
all right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22, to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that, and I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction, because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
Okay.
And can I just, before you
Sure.
rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuondo versus Agard. After the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Right.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. I'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you
Okay.
get that lined up.
Okay.
But like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please, thank you.
Hey, y'all. Did you say 1:15? No. Oh, shit. I forgot what he did say. Let me see. Put in the chat if you heard him say when they come back. Oh, 3:15. Break until 3:15. But that's about 25 minutes, silly. He really wanting a break. Yeah, it took me that long to get it up there. Well, isn't that something, huh? These Utah folks, I'm just gonna say. Making sure that my things are all hooked up here. Yeah, they're taking them like a 20-minute break or so. Beach Bum says, oh, he will just 'cause she doesn't like it or interrupt in the same way he will enforce the law. I'm lost. I better go back up here. So Beachman says, well, the defendant cannot say she didn't get a vigorous defense, a good one. Well, that's another matter. She did get a vigorous defense, I'll give you that. Love Always True says, instead of the family having to sit here and listen to all her rude, unfeeling comments towards them, this should have been straightened out in here to read it for everyone's benefit. They have to just push it, whatever they can push. See what Angela says, I like to say bunch of phony baloney, allegedly, in my opinion. Detective Starter, the state has hardly said anything. Well, she talked a lot, but she didn't say nothing. Oh, wait a minute. Love Always True says, so she just wants to make sure the jury can totally disregard the lead detective on the case. I see. She's trying to get rid of what he said. And Detective's daughter says, Angela, I agree. She thinks it's some phony baloney too. Just Me says, she isn't the reasonable one. No, she's not. Detective's daughter says, get back to her after the break. Seriously, I know how many, it was like 5 things he parked in the parking lot. I never even heard of such a thing. My boss said, you need a big sticky, like a poster-sized sticky board to make a parking lot. And I was like, a parking lot? He said, yeah, when we're discussing something and we can't we come to something that we haven't figured out, we put it on a parking lot and we keep going. Detectives are smoozing up the judge. Ursula's making me sick. Yes, she is. 3:15. Y'all are trying to help me remember. Beach Bum says, oh, he will. Just 'cause she doesn't like it or interrupt in the same way, he will enforce the law. Yes. Angela's our Facebook friend. She sure is. Oh, that makes sense, Just Me says. Go 0307 says, hey, here you are. Hey, how are you doing? I'm on the road listening to you all. Have a great day. Well, Googie 0307, we're glad you're listening in. I see you got you a German Shepherd pooch, and we think pooches are the greatest. Facebook, Angela Davidson said, I'm on Facebook. Just me. Great to see you. Difficult Research says they must be sponsored by the Kit Kat candy bars because they say so many damn breaks. Yep. Beach Bum says, Googie, travel safe. Thanks for tuning in. Beach Bum says, Krisha, I need a darn Kit Kat bar. I'm way overdue for a break. I'm sure you are. Yeah, Kit Kat bar. Detective's daughter says, Wendy, Ursula, Poindexter keeps showing how inept they are. I know it. Oh. I wondered if some of them were over there with that Tyler Robinson thing today, because Nestor was not there. Googie says, I may be going to trial on Monday. Hope it all works out. Yeah. This trial? Well, you'll have to give us the scoop. Love Always True says, can you imagine the Daybell case, the defense saying, just disregard the lead detective on this because they've been able to sit through everything, even what the jury hasn't been able to hear? No. They could say that in every case then. Because every time that, like, whenever their lead detective was there for the whole thing, all of them, and he was there in, I think he was there in Arizona too. Angela Davis said, give me a break, give me a break. She wants a Kit Kat. Hey, Krisha, I heard you've been sick. Yes, she's been sick. Krisha says, just me. I swear there's another Just Me impersonator that I've seen on HTC channel. My heart dropped the first time I saw it, but I'm so glad it's not our Just Me. Krisha says, Googie, you be careful driving, so we'll have you here with us. Just Me, there are several, Krisha. It's crazy. Googie says, yep, I will. Detective's daughter says, Krisha, big hug, sister. Krisha says, I was sick since last Sunday's stream until around Tuesday nightish. Antibiotics help shorten the time, thankfully. But I've also been having major issues with our little ones, behavioral. At Just Me. It's been stressful, Krisha says. Yes, it has. Okay, we got. Googie says, hope you're feeling better, Krisha. Did you see the latest where it's John and Lauren gross on the orange couch? I think I did see part of that. And I thought the orange couch was at um, was at Grayson's. I don't know. You know, my mother used to have a red couch. I'm talking about a red couch, because I saw pictures of it. I don't really remember it, but I've seen pictures in the house, and that was a little bitty thing. It was leather, vinyl, Naugahyde, whatever. It was not cloth, but it was red. Love always says, I'm surprised she doesn't say, make sure to be put something in there with that the jurors should believe all the fake assumptions and gaslighting that the defense told them you and pretend in fact. Lord, I mean, just they didn't talk about the fact that Bryce and Eric might be gay but one time, but it hit. I mean, it's like if that was a factor, that's a pretty big factor. Not that there's anything wrong with it, but it would put some stress on the relationship. I did, Googie, but I watched Jolene and laughed my ass off at the second time around. You going to be at Richins' tile? Mom will be there, allegedly. Oh, cool. Allegedly. Cool. Detective said, I'm here having peanut butter. Oh, that is so good. Detective Sutter's having celery and peanut butter. I love celery and peanut butter. Love it, love it. Well, I guess I could find another one of those walking dog things and play that. Let me see if I can find a walking dog, another one of those walking the dog videos. Okay. Woo!
Corey was in big trouble. She had to have 4 mil. She needed it on the double. She was desperate enough to kill. She came up with a plan. She'd buy some fentanyl and slip it to her man. Then she'd have it all. Kill that man, Corey. Get that money. Go to the Bahamas, Corey. Where the
I know he gave us permission to use his song, but is the music copyrighted? That's what I'm stopping to find out. I don't want to get us in trouble. I think this is an AI song, but I don't know how AI copyrights go. It's okay? Okay. So I'm going to go back. I'm going to play it.
she had to have for a meal. She needed it on the double. She was desperate enough to kill. She came up with a plan. She buys some fentanyl and slip it to her man. Then she'd have it all. Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny. She put some in his sandwich, but Eric was tough. It only made him sick. She hadn't put in enough. She went out and bought more, enough to kill at least 5 men. She put it in his Moscow mule and waited for his life to end. Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny. She booked a trip to a Caribbean resort with her secret lover. She'd done the perfect crime that thought no one would discover. To help with the children's grief, she had someone write a book to give them some relief for their dad's life she took. Kill that man, Corey. Get that money. Go to the Bahamas, Corey, where the days are sunny. Eric's family vowed to take this bitch down. She couldn't kill their brother, get rich and skip town. All this time the police were on to this black widow wife. They finally charged her for taking Eric's life.
They're on to you now, Corey. They know what you have done. Nowhere to hide, Corey. Nowhere that you can run.
While she was in jail, waiting for her trial, she came up with a scheme. It was so twisted and vile. She called it Walk the Dog. Even the title sounded funky. She'd get her brother to lie and say Eric was a junkie.
They're on to you now, Corey. They know what you have done. Nowhere to hide, Corey. Nowhere that you can run.
The guard searched her cell and found her little letter. They gave it to the prosecution. The evidence just kept getting better. Her own lawyer dropped her. Was it for her lies or no money? Shortly after Walk the Dog, the coincidence sure seems funny.
Walk that dog, Corey. Suck your brother in. They found your letter, Corey. No way that you can win.
Soon it will be up to the jury to get justice for this dark soul. It won't bring Eric back, it won't make his family whole. When the verdict says guilty, Corey will never again be free. That bitch can walk the dog straight to the penitentiary.
Go on to prison, Corey. You don't deserve another day. You killed a good man, Corey, and threw your life away.
You killed a good man, Corey,
and threw your life away.
Wow, wasn't that good? Look, I usually don't like the AI songs because I'm old-fashioned and know people that's trying to make money writing songs for real. But it really did sound good. It really did. And I like the both versions of it. I like both versions of it. And I like that country version in that it was a man and a woman, and that gave it some contrast. I'm not really a big country music fan, but the fact that there was a contrast of the deep voice and the soprano I like that, pretty much. And the other one was more like, I forgot. Rock and roll or jazz? He said he wrote all the words and the AI is the music. It's crazy, isn't it? It's just crazy. I mean, what you can imagine you can do, and used to, only talented people could make what they imagined for everybody to hear. Detective's daughter says, when I connect my iPhone to the TV, it doesn't let me listen on my phone, and my TV is slower than my phone. I don't know. I'm slower than me. Do I have my other picture? Why don't we do this? There you go. There's this. I need to make my face bigger so that, because that's tiny. Isn't that tiny? That's very tiny. How can you take anybody that tiny seriously? So I guess I could say hi to y'all. I'm a little less tiny whenever I'm in here. So I know they're supposed to start in just a minute. Oh, only the music AI as well as Bye Bye Corey. She toast. She is toast. Yeah, she is. I think she is too. Yeah, she did some real dumb things. And you know, I was listening to, I don't remember who, but it was a TV personality. And they were talking about Corey. And they said, can you imagine if it was the other way around and that Josh, instead of, imagine that it's a man and a man has like a kept woman and all that stuff. He was just saying, wonder if it was gonna, how that seemed different. I am not cute. Okay, let's see. I saw the little thing moving, so I'm hoping he's coming back. Me make sure I didn't turn it off somehow. I've done that, You gotta watch me on these things. And I may need to turn it up too, because I had turned it down because that music seemed like it was blowing me out. Hey, LaMesa's here. Yay, LaMesa. We're so glad you're here. We are. We're hearing a bunch of arguing about rules. Oh no, they having a delay? There's a delay. Maybe she's talking about a delay in the broadcast. I think. Let's see. My mother's back to working puzzles, y'all. I'm so glad. Yeah, 24 minutes ago he said 3:15. Okay, good. That's what we know so far, which is nothing, but I'm just making sure that So, it's been interesting. Okay, let's see. Yeah, they're trying to not use they're trying to impeach the the lead detective, that they don't take what he says for the truth, and all kinds of craziness. Whew. Yeah, assisted suicide, all that stuff. Good Lord. He wasn't trying to kill himself, and she wasn't helping him with it. Detective's daughter's always glad, like myself, to see that Lamisa. Oh, I wonder where Fancy is today. I just thought of that. I better check on her. I hope she's okay. Now look, y'all didn't have to come in here till after lunchtime. I don't know what y'all are fooling around about. Oh, I see. She was saying that the lead detective, they wanted to disregard his testimony because he sat through everybody's all the witness testimony. But like she said, the lead detective was never he never asked to have his memory refreshed. If he didn't know something, he just didn't know it. I don't know. I guess it's because you have to have your whole face fill up that. My whole face is, I don't know about that. Come on, Nate. Sneak around and tell us what's going on down there at the courthouse. Also, I think Gigi is there. Pretty Lies. She may not be on. Ella. Pretty Lies and Alibis, okay. I'm seeing if she's... I think that she's in the courtroom, but I'm not sure. Pretty Lies and a few observations from Corey Richins' courtroom. The judge, Mrazik's voice is even more Barry White in person. Smooth like butter. Corey is tiny, and the small courtroom, amazing court staff. So that's what Gigi said. So I'm gonna put that in our chat for us to look at. Per Gigi. Angela Davis is no, sorry, I was responding to Dee Dee. It was the minute there's a delay in watching the YouTube, Facebook. I said, okay, that's kind of what I thought. They are never synced up exactly, in my opinion. But they do seem to be late by about 2 minutes. I see. See, well, that's the thing whenever you're doing this, you really don't know what the other people see. And, that's why if you're doing stuff like and somebody's paying you for it, you have to test it on a lot of different systems and different kinds of internets to see if it works. Damn it. I don't get to do that anymore. Lamisa. The plan was to make the IO look incompetent and disinterested and the knowledgeable. I guess because they didn't check out this and you didn't call that one. They're trying to just make them look like that. The lead detective is supposed to sit through it if they can. That's what I thought that one did in Rexburg. And what was his name? Hell, our favorite guy from Lori's Child and sat through all the trials. What was his name? Call Gigi. I'm not going to call and bother her. She's at work right now, and she's going to have some good scoop for us, I'm sure. I take sleep medicine. I fall asleep on the night shows. I fall asleep on the night shows, too. Every time. She said his voice is even more Barry White in person. She's so silly. I think her top makes her look fat. Her top doesn't do her any favors. I think I saw her front row behind the defense. Besides the blue suit, she is a nice neutral olive. Does she have on glasses? I think I may have seen her too. Does she have on glasses? Gosh, why can't I remember the cop detective's name who helped so much with JJ? Hermosillo. That's who it was, Hermosillo. Handsome guy, it was Hermosillo. Just me, detective's daughter says, just me, I take new sleep meds too and stay as long as I can. Whew. Detective Hermosillo, just me. Yep, Ray. Ray Hermosillo. That's right. He sat through all of it. Just me, Hermosillo. Ray Hermosillo, says Lamecia. Yeah, Wrench Ray Hermosillo. Absolutely love him. That's right. Lamecia says, he honestly gave me a tiny bit of faith back in law enforcement when it comes to the kids and abuse, violence, and etc. He fought hard to get justice for sweet JJ and beautiful Tylee. Yes, he did. Yes, he did. Thank you, Ray Hermosillo, for working to find those babies. Get justice. Yes, Gigi's wearing glasses. I've got to check. I don't know what these people are taking so long, but it's making me think I have messed up something. Because these people over here in Utah, when they get tired of being up there, they just turn it off. Kara Bird says, I accidentally called Ray Rags for an entire stream of Kobe's. He was so kind about this dumb autocorrect. Rag. Kira, he seemed so kind. Lamecia agrees with Kira. He is a very good man, says Just Me. Lamecia says, I'm glad through all the pain Cresha K, Larry, and everyone endured, there was some real genuine hero like Ray. Yes. Yes, that's right. You know, I'm beginning to worry about this judge now because he said that they would be back. Let's hide this. Now that ain't right. Where's my banner? This is the time. At 3:15, it's 3:27. Is he having to yell at them women? Pretty lies and alibis. Have you got any? Oh, you follow her. Huh. Huh. Well, let's see what Nate says. Nate, are you getting any news over there? The fraud packet. We need to get a fraud packet for what's her face? Corey. Well, who would have believed they would have fooled around this long? It's about to make me sleepy. Detective's daughter says he's probably arguing with Ursula in the chambers. Kara Bird says Professor Ursula unbridged. Oh my God, she does look like Ursula. She does look like that. See, I'm not really up on all the Disney princess, Wicked Witch people. I did know about them though, because I think that was Little Mermaid, and Little Mermaid was when my kids were little. But the newer ones I don't know about. And I think that when I was a child, the only one I went to see was 101 Dalmatians. The cartoon, 101 Dalmatians. I don't really remember. Exfil, as mean as Cruella is, oh, excuse me, I always loved her hair. Kara Birds wants to know, Judge Smooth Voice, where are you? Like, I'm fixing to pull up, Judge, Your Honor. Send me to the electric chair. Okay, Lamecia says, anyone, let's see what this is. Anyone here know how the Tyler Charlie Kirk hearing went? Is it still ongoing? Andrea Burkhart is covering it. I'm going to find out about that, but what I had understood, they were arguing about having cameras in the courtroom and whether some of the still photographs or something that they had would be prejudice to the jury, and I don't even know what all they were arguing about. But Miss Nestor was not the one arguing. I don't know who the people were, but they acted like they were his defending attorneys. But it did say there'll be another, I wrote it down, April 17th is when the next hearing will be. Lamecia says, yeah, it's all about media coverage and prejudicial factors. Yeah, and they were like, well, we have no reason to believe that people would be that interested. Are you crazy? And plus, they're saying that they want to speak about the media's trying to spread misinformation about Mrs. Kirk. No, Mrs. Kirk has been spending years distributing misinformation about herself. Well, I'll have to get her thing. Yeah, they did finish. They finished, I think. That hearing stopped right after we started. Excuse me, because I have been watching it. Kirby says, oh man, Cruella scared the pants off me. So did the Siamese cats from Lady and the Tramp. Y'all didn't know about the Siamese cat. We are Siamese. Yeah, if you please. And they're Siamese if you don't please. Lamecia says, I watched some of the Voir dire last time, and Woods, lots of Mormon overlap. Yes, in that situation. I think it is too. I've never seen so much overlap in that situation with what we're doing. It's crazy. And two, it's in Utah County, and Utah County is the county that let Hamplin go free. And Utah County is the county that screwed up, well, several things that they let that district attorney David Levitt go. He got out of trouble. He's in Scotland in a castle someplace now. They have not been known to give justice to everybody over there. Let me see. Yep. You said it, Donna. Preach. Yeah, I don't think he's going to get a fair trial in Utah or anywhere, because it seemed like that he didn't do it to me, but they said he admitted it. I don't know. Maybe his parents thought that he needed blood atonement, and I don't know what I'm talking about. I don't know what I'm talking about. I need to shut up. Oh, mercy. I don't understand why people, I mean, maybe somebody, I am not a Candace Owens fan. I've seen her before. I think she's a real pretty lady. I knew that she was friends with Charlie Kirk. I really didn't know that much about him. But I have been listening to some of her stuff, and I'm sure some of the stuff she says is over the top, and some of it may be true. But I'm just saying, excuse me, she's been talking about some of the same stuff we're talking about, and she's up the same tree. However, I believe that Charlie Kirk probably knew about the stuff too. I don't know if he did or not. I don't know. But as Kresha has said, as we've all said, be careful about your heroes. Don't hold anybody up on a pedestal, because all these people are imperfect and make mistakes, and some of them intentionally do stuff. So be careful. People don't treat everybody the same way. If people treated everybody the same way, then there wouldn't be any question about a lot of stuff. T. Texas daughter says, I live in Taterland. It's bad enough. Sure no, wouldn't live in Utah. Oh yeah, I heard that in Taterland they're trying to, they're trying to fix it, to unmarry the married gay people. They want to take back that. Maybe they're not going to unmarry them. Maybe just nobody else can get married. I don't know how they do that. But, you know, well, I guess you can make laws about stuff, but it messes up their insurance and their bank accounts and stuff if they've got paperwork for their legalities. Lamecia says, Kira, honestly, Canada is flawed for sure. But we are multicultural as fuck. Really, and you know, these people should be too. I'm just telling you, if you look at the map of the United States of America as it stood in 1776, it was only a very small part of this huge piece of land that we now call the United States. It was a tiny place. All the rest of it, just about, was controlled by Spanish and French. It's a thousand wonders we all don't speak Spanish, French, and English. Because those places, the town where I'm from, is Hernando de Soto. Hernando de Soto was a very famous Spanish conquistador, discoverer. We're very proud of that. And now people don't want to talk about Spanish. But I remember when my kids was in school, they had a Hernando de Soto week, and believe me, we had to make those kids a conquistador hat out of tinfoil. Tinfoil conquistador hats. You can imagine how rattly that was in that cafeteria. 200 or 300 kids wearing tinfoil hats to be a conquistador. Are y'all laughing yet? How quickly things change. I'm worried about this. Excuse me. Where is the judge? Judge, you're making my break till 3:15 sign be a lie. Just a lie, just a lie. Well, Nate, did somebody fall out over there at the courthouse? Okay, Gigi. Y'all, I'm going to have to cough again.
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right. Let's, Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law. So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then, let's look at the first 2 pages of the additional instructions that I sent out. Page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they.
No objection.
It's of Muji second, CR 415, which is the custody informant. Mr. Burmester.
The state objects to, number 1, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
The reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant. An informant.
Draw the distinction for me. What would you see the informant as being?
And I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say, they don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So that's, and I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony, for obvious reasons.
Let me spin a hypothetical here related to the facts of this case, but not from the facts of this case, to make sure I understand your position. So it sounds like if somebody heard Corey, or somebody came to law enforcement and said, I have information that might be relevant to the Corey Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Corey Richins, once upon a time in 2022, in January 2022, asked me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
if we alter that just a little bit, the defendant, whoever it is, told me something, that they killed somebody, or
Right.
they shot the gun, or
Yeah.
whatever. That, I think, is different. That's not a witness to the crime. I think if she said, if the witness had said, the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay, I understand your position. Ms. Nestor?
We have no objection to the new informant instruction or to the making the immunity instruction just general. We're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmester is taking the position that as a matter of law, it's inappropriate to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. There are people that gave information and got a deal out of it, whether, I just have never seen that distinction made in the past. I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests,
Travel to Nevada.
to make herself feel better because she feels guilty. All of that is not covered by, those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask a different question? I don't understand the relationship between the first sentence and the last sentence of these these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
that is the last sentence is dealing with the scenario where they find no other reason to find guilt
Right.
other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony and informant alone. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why
All right.
that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauber's testimony alone.
No,
You'd
they
have to-
certainly can.
You'd have to add some
Right.
language to that statement.
Correct,
Okay.
absolutely.
All right.
Absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay. Then, if you would please turn to page 3. This is a revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor?
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right, and then, Mr. Burmester, if you look at the 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objection, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed, oh, I gotta change the numbering, I'm sorry. This is why we go through these things together. All right, bear with me for a moment. The elements are 1, Corey Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the modifier attempted to before intentionally or knowingly cause the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes, I
Okay.
believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
You know, it was supposed to be beyond, no, that is something I just need to edit to match the original. I know what you're gonna say. It's gonna say circumstance or circumstance is on page 5.
Also, I just caught by looking at that on page 4, the one before, it should say listed in element 3.
Correct. I made that
Did you catch that?
interlineation. I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Corey Richins performed or committed to commit this crime. This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there to get the conversation started.
So I'll let them talk first because I'm interested to hear what they say.
Other than Richins
Yeah, got it.
spelling, I think that's what we're gonna argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio, was
Because of the forged name?
because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the claim, took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my
Do I
concern.
have that right, Mr. Burmester?
Yes, Your Honor,
Mike,
it's just
go ahead.
like frequently, there is a, when you have a forgery, there's a corresponding count, like a
Right.
theft or
Right.
theft by deception, whatever.
So, the only issue I have, I mean, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry, I cannot remember her name. I don't mean to be disrespectful, I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
Sand coats.
Okay, good, Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you? That was not something that mattered to them. So we know that Corey had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. They each, it was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So,
I mean, I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm
right.
not making a finding.
correct. So I don't understand how, if if the claim on the death is based on a death that actually happened, and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or
Yeah,
not.
but I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Corey Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as a beneficiary on behalf of someone. Like, I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you
And
can't
that-
forge a signature on it.
Well, if she had authority to forge if she had authority to sign his signature.
But that's a
it's-
big if, that's in factual dispute in this case. We're just talking about legal elements here. Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, besides the spelling error, any,
Wait, before we go on,
Oh,
can I
I'm
just put a
sorry.
clarification? So I can argue, I'm just concerned that if this language is in this instruction, that I'm not gonna be able to get up there and argue, this may be their theory, but we don't think any of this is a crime.
you can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
I just feel like you're telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, and you tell me if there's a more artful way to do it in your
Right.
view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day, to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean, I just don't
But you don't have any burden.
know, but we are entitled to theory of defense instructions. I mean, if you're gonna put their theory in, I just think adding that part in the bottom is problematic for a lot of reasons. I think, just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No?
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today, so I don't know that we're going to fix that in this case.
I mean, there's evidence that, whether they believe it or not is another question, but there's evidence that Corey Richins filled out an application for insurance, submitted it
Yeah.
to the insurance company, and they eventually paid it out.
I don't disagree.
Yeah,
Yeah.
so-
Whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
Absolutely, and I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head.
I
That won't be
understand.
argued. But it does help us distinguish unanimity between 3 and 4.
What-
That's the
Well,
one. advantage.
I think also the dates.
The
do that
dates are
for you.
different,
Yeah.
absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Now, you can stipulate it to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm gonna argue it correctly, even though it's not written correctly on this instruction.
Or I think
Yeah.
what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
Right,
the evidentiary foundation and the state's closing argument will make it clear
Will cure
that
it.
they are alleging that there were multiple acts committed here.
okay.
Is that fairly stated, Mr.
Yes.
Burmester?
We are definitely not making the argument that somehow the instruction is improper
Right.
or
Yeah.
unlawful.
Okay. Okay, and then, anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right, and then count 5 is just the skinny down version of element 4.
Did we skip, because on count 4,
I
we
didn't
were,
make any changes.
you left it the same. Got it.
There were no objections to count 4.
Wait, I thought count 4 was the one,
Did I miss some? I apologize.
yeah,
Let me take a look.
let me check.
I don't have any handwriting on count 4.
Just a moment. Okay, let's see. There's one. Just a sec. Two.
Mine is clean as well.
1 and 2. Just a moment, Your Honor, I'm so sorry. Count 4 was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from
That-
the statute
that had the
regarding
fees.
fees for services.
You're right, then, no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
Yep, no objections.
Okay, great. All right. I think that only, oh no, before we get to spoliation, Ms. Nestor, my apologies. Any, did I hand out the special verdict forms? Did I bring them with me?
Did you, the all amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
Well, dang it, I walked away to go see about my laundry too. No, I didn't fall asleep. I'm here. So, are we done for the day? What did they say? Oh no, here he comes. Here he goes. There he goes. Well, I guess I'll have to go back and find out.
Of different body parts, and you've got to be real specific in the counts. Ambiguity. It's clear.
I just think
I know that
They're arguing.
Special verdict.
No objections.
No objections.
Very good. Okay. Ms. Nestor, I have a list of practical things I need to talk about, but did you want to talk any more about spoliation sitting here today?
Yes,
Go ahead.
thank you. Your Honor, may I remain seated?
Yes.
Thank you. So, the court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus, or whatever the word is, residue, I'll use an easier word, residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the,
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
I don't think
Did
that
Detective
last,
O'Driscoll say that?
no, it was objected to because it was hearsay. Is my
I don't
recollection.
know whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have, they don't, like, the Summit County sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
Not that bottle, no.
Okay.
no,
Meaning no affirmative evidence, or they don't have that bottle?
they don't.
No
have-
affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know that the young woman, and I apologize, I cannot remember her name either, I'm just blanking right now.
Dr. Ulmer?
No, the
Ms.
lady who
Gibson?
checked in the body that had
Oh.
the tag, the red
Yeah.
tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure. So I know that she did, my recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. It's clearly it's gone because it'd have been here if it wasn't.
Oh,
So,
but, yeah, I mean, let's come back to spoliation, right? You have to first show a violation, or that a duty to preserve
Right.
existed.
exactly,
Then you have to show a violation.
right,
Then you have to show prejudice.
right,
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So
Well-
who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial, because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
Well, we can do affidavits as to that.
The evidentiary record for trial is closed.
No, for your evaluation purpose, I mean, it's not, I don't think your finding is based on what happened in trial.
No, but
I mean, because
I mean,
all the time on
the
TV.
evidence is closed. Closings are happening Monday. To the extent you were a party, wanted to make an additional evidentiary showing and have the court make findings sufficient to support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is, that time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not that.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing, it was gone. So we've never had the opportunity to test it, submit it to a expert, or have it, or use it at all, right? So it's missing. There's no question there's a duty to preserve it. I mean, they thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. I mean, we've just not come across that in any way. But there's definitely going to be some gross negligence here if the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but
Not,
keep going.
not right next to the body, there weren't. And, you know, there was an unknown dust on the nightstand right where the pill bottle was, could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? Like, one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you know, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. It may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever.
Right.
I need more here.
Right.
I understand that this is a good faith argument, but spoliation requires findings, and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and
Right.
prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that it's material. I think the only thing that's in question is the breach, right? Like, to what level of culpability was the breach? And
Or was it breached at all? I mean,
Right.
there are things such as rule-based preservation schedules
Sure,
that
sure.
absent, for example, your client certainly knew that the body was taken, right? She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm
Right.
just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. You know, it puts us in a position where we might have to have, like, if,
And to be clear, you are not limited from making the arguments you just made to me
right,
to the jury.
oh, we will,
Where's the bottle?
right. No, we'll definitely do that, but what I want is the inference that you got to assume it helped us.
That is, I sit here today.
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Okay. Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in, but,
After you've resolved all of this, I just
Oh.
had a request.
no problem. I'm happy to hear you out in just a second. Okay. Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So we're
Fine.
good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that,
Yeah.
Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind, but if he does, what is the time you want us to?
Whatever you all agree to. I
We'll,
just,
we'll do it.
I'm inclined to order it if you folks want it, but if you've agreed to
Yeah, we-
proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday. And, I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now, you can put what's in, and if you want to use some creative little thing that is just for,
Demonstrative purposes.
demonstrative purposes, the other side's not gonna be able to object to that anyway, so
Understood.
we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing your on-reading instructions and closing
Sure.
arguments. And so if, Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the
Ms.
state is
Steele
present.
was here trying to talk to,
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help. If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup.
Right.
Backup. So if we could just, before the exhibits go back,
Yes.
give us a few minutes to make sure we're all in agreement that that's what should go back. And we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that will take longer than a few minutes and
Yeah.
will involve somebody from both sides of the beat, Brittany, after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for.
The jury does.
The
not
jury, but
defense counsel.
I don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits. They're going back, correct, Mr. Burmester?
Yes.
I believe so, but I will check with that. I mean, we were, there weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood, they're all portions. Like,
Right,
for
okay, good,
example,
good. I was like, just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
a companion transcript.
We did agree to those.
Okay.
The parties did, but now I'm panicking if there was accidentally
Oh.
some big transcript that slid back past us that we didn't see.
I don't think so. Brittany
Okay.
just wanted to confirm,
Okay.
based upon the conversation we had on the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she
Right.
understood the state of affairs.
No, I
If
think-
it's been admitted
Yeah.
as an exhibit,
It goes
to the
back,
jury.
right.
Yeah.
I agree.
Okay. All right. Anything else today, Mr. Burmester?
No.
Ms. Nestor?
I assume, since we're doing so good and we're so far ahead of schedule, that you're not putting a timer on our closings?
No,
Okay,
not putting a timer on the jury either.
okay.
All right, I'm gonna have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing. We haven't lost a juror in
They
a
are a
3-week
hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They're just, they need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, Ms. Afternoon, Ms. Nestel. Sure, happy to listen.
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is, we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody can or anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly, and there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep, just to make sure that they get in. Our request would be that they get the second and third row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for more of that before 0800.
So I'm just going to sound this out in real time. What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space, I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
Certainly neither
on
did
Monday.
I. Yeah.
If those rows are not filled, can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear, what I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Corey Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Corey Richins' family, and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I've said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richins' family and see if they need that second row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an
Okay.
expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
I have to remember to turn that fan off every time I. What a family. Oh. What in the world? Okay, so they're trying to figure out who can come, and it sounds like they're not going to have anybody from the public except for the people who get tickets or whatever. I don't know what they're doing. Having a break is what they're doing. I don't know what I'm going to cook for supper. I should have got something to cook for supper when I was getting lunch. But of course I didn't. Angela Davison said the judge is taking a 5-minute break to decide who will be allowed in the courtroom. Family, public, media. Is what I gathered. Ay, ay, ay. So, no trial tourists is what he's saying. It is a small courtroom. I think it's more important that the family get it. For a fact, they're going to limit media. But think how terrible that would be. And do you really think Corey's going to have a whole bunch of people there? I expect this will go on through this next week because, well, no, yeah, if we're counting the verdict and then I don't know whether they'll do the sentencing publicly or. Love always says maybe they don't want to see her sit anywhere near her family. Well, I would think they wouldn't want to, but love always truth. I do think they should discuss with the family, like, how would you like everyone to be sitting in the courtroom? What makes you feel more comfortable? Okay.
This is going to be the plan for closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richins' family and guests or Corey Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind, they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, Court Security Director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for, unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of that.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day. Okay? Means you got to be here, somebody from your team and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day. All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else, Ms. Nestel?
No.
Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted to talk.
All right, y'all. The closing is on Monday. Court's in recess. I'm guessing till Monday. Is that what y'all got? I'm not sure whether that means anybody else can come. There's no use in sleeping there, or what are they talking about? I'm not sure. Oh, Kelly Blue Who says, "Hey Donna, I love to hear you. May your inspiration become clear. Happy Friday the 13th." Here you go, Chris Palmer. We're sending Chris Palmer some pom-poms or whatever he said to send him. Lamisa says, "Is Kresha going live this weekend?" Ooh. Well, look here. We'll just have to ask her.
Bippity boppity boo. Sorry, I was up on a chair and I was painting the very top of the freaking wall to the ceiling. Anyways,
Yeah.
I was like, oh shit, let me hurry up and jump down. Anyways, so
It looks
how's your
like we're
host?
in. My whole family doing okay.
Good.
It looks like we're in recess till Monday, whenever they're going to have closing statements, and I'm not sure what all that meant about. They must have people assigned seats or something in there.
Yeah,
Who
that's
ever
what he
heard of
just
that?
dished out. He was just talking about, I mean, I can't remember what he said, but it was about who's going to sit where and blah, blah, blah. I've never heard of family and, or whatever, and guests or whatever. I'm like, guests? What the hell does that mean? That's interesting.
They get 24 wristbands per day.
Dang. I mean, here, I'm just saying it's so different than Idaho and even Arizona. It's
Right. So,
it,
I mean,
mm,
like people like Gigi that is out there, and I don't know if
it should
Lorna
be
and them have
here.
been there in a few days, but she should be able to get in. Yeah.
Yeah, Gigi. I knew she was going. I just couldn't say nothing. I didn't say nothing. Uh, and then my mom will be there. She's on her way.
Well, that's
But I
good.
mean, she wouldn't, she already had her plans, before just closing all of a sudden, resting and all that good stuff. It was
Oh
supposed to be
yeah.
in what, week 3? And then,
Yeah.
but 5 weeks went to what, I guess, we're day 14 today, so 2 weeks and then some change. Anyways, I think I heard this, and so I don't know. I keep hearing myself through, and it's messing me up. There, okay, whew. It really messes with me. Oh, let me get back on track. Ugh. What I heard was that I think Nestor said that uh, she named the attorney, and I don't think it's the man. I think it's the other lady, the one whose voice grates on my freaking nerves. But I don't know if that's what y'all got too. If it's going to be the shorter lady. Y'all know their names. I don't know them all. Um, and then there's not going to be a time limit, and I think that's all I can retain.
Yeah, I didn't. I saw that some of them weren't there, and I wondered if some of that team was down there in oh crap, in Orem at the Tyler Richins. What's his name?
Tyler
Tyler.
Robinson, I know, I watched that earlier, and then I was like, "Man, this is so damn boring." It was like 6 different freaking people I watched go up there and bitch about freaking media and not media and blah, blah, blah. I was like, "Man, this is crazy." I think it's wild. They're trying to do the whole sealing of the hearing, the documents, and things like that. It's just so familiar with what happened with Lori. Don't like that.
And I heard him make some comments about that there was a lot of people who were
Yeah,
disparaging Miss
about me.
Kirk.
Yeah, media. Well, she needs to freaking act right. How about that? Change your attitude, lady, and then you won't get the freaking clap back. That's my take. It ain't got nothing to do with the trial, the alleged trial for the alleged murder, assassination, whatever people allegedly want to call it.
I know last
Anyways,
night I saw Candace showed the video from behind Charlie,
mm,
and he
okay.
falls out of his chair, but he was not. It didn't come out. Anything come out. There was nothing to see back there except for his necklace. His necklace
Mhm,
blew up. He had a necklace
mm,
on, but I'm just saying. There's no way that the size gun that they had
mhm.
made the hole that was in him.
Yeah, I
And
mean,
I don't.
I was following it really close in the beginning, but then, I mean, I kind of catch I catch it as I go. And so I
Yes,
haven't, I saw a thumbnail or something about, and the way they titled it threw me off. They said something about Charlie's tummy, and I was like, tummy or stomach? I don't know what you're saying. Anyways, I haven't looked at it. I don't know if that's what you're talking about or something like that. It wasn't Candace Owens, but I mean, it just the whole thing is insane. The whole goddamn thing is insane. The fact that I forget the name. There's a guy who's in politics who is just one of these. It's oh my god, it starts with a L, the last name. He lives behind the university and happened to catch allegedly catch Tyler Robinson with TMZ. Send it to TMZ and Phil Lyman. Okay, I just remembered. And just it's a whole bunch of fuckery, and I don't like it. It stinks. It smells really bad. And I would love to pick your brain, Lamisa. If you ever want to come on, okay? Because this would be good. Just to hear, just to talk about the laced, coated, heavily coated Mormon, uh, you know, signs, elements, whatever to it, I always say drenched is drenched. It's hard to see the chat from my phone. I'm getting old. Special request of victim advocate asking for victim family to have the second and third row. Thank you, Kelly Blue Who. How you doing? Then again, it feels like the whole world is insane. Absolutely. Yes, this is another psyop, right? I don't understand who's responsible. That impossible shot with that gun in the wound. I remember watching it happen live. Oh, I didn't. I'm so sorry you saw that. I was in complete shock. I think that's another part of the psyop is to traumatize people. That's their whole thing. That's their game. You're good, Donna. Come on.
I was just going to say, that is the thing that happened is that, you know, within seconds, I don't think I was watching that, but I was watching something else, and maybe some chat someplace, and in the chat somebody said it, and I went and looked, and they, it was before they even knew he, if he had died or what, whenever I first started looking at it. Of course, it wasn't any time that, but it was just, but they wanted,
She scattered him.
everybody was like, he got shot, but I don't know if he did get shot. I don't know how they killed him. Or if
I don't
he's
even
even
say
dead,
it.
but
Exactly.
ex-
Valhalla is just so gross, right? I mean, just that part of it where it's like there's extra actors and when the president is freaking piping in, get go over there to your desk, okay? You got all kinds of like shit to handle. Like I don't know. It bothers me when he comments on a case, okay? Because, I mean, I've already seen how Biden, at the very end of his presidency, started pardoning all kinds of criminals, in my opinion, allegedly. That's what it looked like to me. And I mean, that's what they can do. They have pardon power. Um, I'm good. I just don't like stay in your lane. Okay. Like whenever Trump and what's his face? The cross-eyed dude, Cash Patel, whenever they're commenting on Nancy Guthrie or it's gross. I don't like it. I'm just like, what are you doing? But people just fall for it like it's biblical truth, or you know what I mean? Like it's the word. I don't know.
and
I
what's
guess
so important for people to be able to believe other people whenever they, if someone says duck, and they've been yelling duck for ever, how long, you won't duck. And so it's
exactly.
important.
That's it. Yeah, Jason was saying that the other day. It's to desensitize us too. We don't. We don't react. So I mean, when Corey is in her body cam footage and everything of her, you know, I can't say that I would be very reactive myself because I kind of just sit there, I freeze. And I mean, I think that's kind of it's kind of in a privileged spot is what I'm saying, to be like, "Oh, I would do this or I would do that." We don't know. We don't know. I'd freeze. I know I would. I think I would. For at least a time, I would freeze. But I don't know. Not trying to defend anybody, but I'm just kind of pointing that out. I guess from listening
Exact.
to Dr. John go over it, he's like, she's, he was just criticizing or doing whatever he does, spinning a narrative. And so I'm critical of him. And he's just like, if she wouldn't have cried, then he'd have been like, oh my God. Yeah, it'd have been that. So, and then Lauren just likes to put everybody down and be judgy. Yeah, we are dangerously desensitized. I'm sorry, Donna. Yeah.
I was just going to say that I don't know how I would act in a situation. I really don't, because I act crazy in other situations that aren't as, like, when my little dog got sick, I laid down on the dang floor of the vet's office, flat out.
Yeah.
You know,
Yep.
that wasn't appropriate, but that's what I did.
And just can you imagine people judging you for that?
I'm sure.
I mean, like if everybody across the world was just analyzing every little thing that you did. That's
That
oh, I can't imagine. Nobody likes being in that kind of hot seat. I mean, some people do. Some people are just drama queens, but some people are guilty and they're trying to cover up. I don't know. We don't know. We weren't there. So we just have to trust in the judicial system, what's left of it. And, hopefully they make the right decision. Hopefully with Tyler, it seems like I was telling Donna this yesterday when we ended, yesterday stream. We were talking about how, well, I mentioned, that they'll like throw the death penalty on the table like they did. I'm not, and look, I'm just throwing things out there because it's the only thing I know to access. I'm not in this field. I'm not a trial expert. Okay. Like some people, but they throw like the death penalty on the table if they have it and they use it as a bargaining chip, it seems. And so let's just say Tyler was set up, is still being set up. Let's just play with this idea for a minute. Then here he is going through pretrial motions, yada yada yada, heading to trial, allegedly, and they throw the death penalty on the table because, oh my God, blood atonement, right? And so then he's like, well, shit, you know? I mean, I try to picture like if it were me, like if it were me and I was put in the situation and I was innocent, right? Then, oh my God, do I go ahead and just roll the dice and just be cocky like Chad Daybell and just be like, oh no, I'm gonna be fine. I'm gonna get off of this. Um, or do I take a plea deal and remove death off the table at least because, oh my God. So then what? It's just, I don't know. And then like with Lori, in my opinion, that was interesting how her death penalty was removed. If anybody deserved a damn death penalty, it was that woman. Okay. But anyways, I don't know. I just kind of think about these things as if it were me or someone I love. I mean, at the same time that Lori and Chad were going through all this trial stuff and they were being jailed in a county jail awaiting trial and then went to prison, my brother was in prison. So there's somebody I love that was in prison that, I wouldn't wish anything, a hair to be harmed on his head. Whereas with Lori and Chad, we're like breaking out the fucking pitchforks, slinging hot pizza pockets, Chad and Lori. Like we're just like burn them at the stake, and I don't like that. I I I did it myself, and then I'm like, ew, I don't like that. I didn't like that about me, and I don't like seeing it in other people. It's like everybody's just so quick to convict, but imagine if it were you. Imagine you were innocent and imagine you're supposed to be given just as much as we think victims' rights, right? And we say that the perps usually have way more rights than we do, which I mean seems true a lot of the time. But if it were you or me, I mean, I'm glad that Nestor would be getting on everybody's nerves. If it got on everybody's nerves, like I don't give a shit. She's doing what she's fighting for her defendant, like I want somebody like that. I want somebody who's not just gonna do the bare minimum or be in bed with the prosecution, you know? Anyways, I don't know. For what it's worth. I just it's just it's not just if it's convicting somebody wrongfully. That's that makes no sense to me. In my gut, in my heart.
And Eric seems like, so he's a lovely person. It seems
Mhm.
like. Can you?
He was, yeah.
And so, I guess. But I'm just going to say my brother was the kind of guy that would like hunt all the time like that. And I just, all that kind of stuff too. It was a weird, bad situation. Not the kind of situation where you can kill somebody that is okay, but it's a situation that is complicated.
I don't know
And
what you're talking about. What do you mean by like the hunting stuff?
I'm just saying he was gone a lot doing those fun things or
Oh,
whatever
okay.
they do. And
Yeah.
my brother was gone a lot. But too, as I'm saying, it's hard for me to believe that he went hunting for, trips that
3
were months at a
months.
time
I
and did
know.
not and did not ever like drink a beer or anything like that. It just seems to
I
me,
mean, if he drank Moscow Mules, it's like, hello.
yeah.
Uh, I mean, come on. It's like there comes like a memorialization or what do you call that?
Yes.
Where people believe that victims are just perfect, and
And
I
you
mean, you
can't
can't
say
be like
nothing
that.
about the dead. My brother,
Right. So what the hell you do?
oh,
You
he
just
was
try to
something
humanize
else.
them as much as you can.
And so when he died, it was like, oh gosh, I just have to bury up all that crazy junk that he
Your
did throughout
brother?
the year.
I didn't
My
know
my
that.
my younger brother was a big mess, and
Oh, I'm sorry for your loss.
I'm
Big
sorry for my
brother.
loss too. Double crossing, no good for
Oh,
dying on us. Uh, he no, he was the baby of the family, and my mom lived with him until he did die because my mom wanted to be with him.
oh,
And so it
a
wasn't
little
till
shit.
after.
Little
Yes,
spoiled brat.
it wasn't till after he died that she moved. We moved in together because, and he liked to drive her crazy, but
Yeah,
she
she worried
was
about him
she.
probably.
Yeah, because she thought he didn't eat right and didn't
Oh
do
yeah.
this right now, and so
Yeah, she
anyway,
got to take care of her baby one way or
but he,
another.
yeah, and so, whew,
Wow. I don't quite get the going hunting for 3 months at a time. I mean, there's Mexico right there. Think about Alex, how he went to Mexico and then boom, he died. I mean, just this shit happens. I understand that their mom was a counselor and about a drug, anti-drug, blah blah blah. But I mean, that doesn't mean that he didn't use. That I mean,
hey, I want to.
coming from
Oh yeah,
somebody
that.
who used, I'm telling you,
Not
you
only that,
lie and you
it's like
use.
the preacher's kid, preacher's kid or something. You
Yeah.
know, I wanted to ask you about. So Eric's mother, I heard, died, and so that lady that's been sitting with Eric's father back there, is that hers? Is that his sister or the oldest daughter? They all look a lot alike.
You want to know if
You,
he's single?
no, for
I'm
God.
messing
Well,
with
I do.
you.
Look, I do think he's cute, but he's
I know.
Mormon.
I've been hearing your comments.
I do
I'm
think
giving you a
he's
hard
cute.
time.
I think he's cute,
Well,
but he like I said, my brother's like, we got somebody we want you to meet, but he's real secretive and don't want people to know where he lives or his name. I was like, well, heck, that
hmm,
does not sound fun to me. Not
right.
unless you're wanting me to be a detective and figure it out, not to
Well,
date.
it's in your name. You can't be having it in your name if you're not going to be a detective. No. I was going
Exactly.
over a transcript earlier from Lauren's live when she went and did her recap of uh mute yourself for a second. I'm sorry. I'm zoning
Okay,
out.
I'm sorry.
Um of Carmen, the day 3 or day 4 into day, yeah, it was day 4 into day 5. And so what I do is I like copy the transcript and I bring it over and I kind of just summarize it with, in Google Docs. And so I'm going through point by point. I mean, these are Lauren's points. Okay, this is what she brought in. But I mean, I'm sitting here like, oh my God, that really stands out. It was about, whenever uh they were talking about the drugs and the levels of the fentanyl and the searches and things like that. And Carmen came in, I think it was her first day testifying. And I'm just like, oh, well, this doesn't sound good. Like it seems like they have a lot of, or prosecution has a lot of points or I guess you would call it circumstantial evidence, but I don't know if they landed the plane. And I mean, again, I'm just looking at this with like no emotion. Like there's no emotion behind this. I don't have a dog in that hunt, of
I
course.
want to say, I want to say one thing. Can you hear me?
Yeah.
Okay. Here's what I want to say is that I sort of kind of felt that way in one of Lori's last trials.
Oh no.
And
I get
I
it though.
felt like and so I totally, get that maybe we think that they had not landed the plane, but it seems to me that they landed the plane in the
Yeah.
closing statement. And so
That's
that's what I'm hoping for.
okay. I mean, and that's likely what happens. You know how they scatter it out over days, and I'm ADHD. I don't. I don't- Next day, I'm like, I told y'all, Men in Black comes by and they like zap me. I don't remember what I just freaking was working on before I went to bed. Anyways, thank you, Soulshine 1985. Thank you. Appreciate that. Thanks for all you do and always great research and interesting conversations. Thanks, Kresha and Donna Twinkle. Thank you, Soul. I was about to say Soulless. My God, you can come kick me. Soul Shine. I can't see. Let me make this larger. How about that? Okay. Y'all can't see what I'm doing. I'm just increasing the font size. But thank you again. Thank you so much. Very kind. Um, I don't know. I mean, I can see that though. And it does get a little scary when, I mean, especially with Lori and Chad, it's like, oh my God, my mom was on their hit list. And I'm just like, oh, if they don't go to prison, then I mean, they're out here. They're on this side. I don't know. I don't want any dangerous people out there plotting. One
Complain
thing,
about this.
huh?
I was going. I was going to say it just makes me makes me mad all over again about the fact that they didn't bring in those emails that showed Chad was part of it and why they didn't charge his ass.
Who's Chad? Oh,
Chad
Chad
Daybell.
Daybell? Okay, I
I'm
was
talking
like,
about
wait.
I'm talking about with Charles. I'm talking about with Charles' murder.
Yeah, oh yeah. But I mean, I understand now, I guess. I've had many years to come to terms with that. But just expense. He's locked away. He's death penalty. So Lori has 7 damn life sentences now. She's been collecting them. And then she compared herself to the damn Nephites after the fact. You're like, wow, she ain't learned shit. So, anyways, um, what was I gonna say? Oh, one thing I haven't really heard a lot of, but then again, I've been in and out, is a lot about, like, I haven't heard Corey fighting for her kids or being protective of her kids, even. Yeah, it's weird. I don't know. I guess again, I've not
Only
been
at
hearing
at one
myself.
point there was some let's see, there was some emails or maybe it was conversations she had with her brother or her
Yeah.
mother. She did say that that if they got divorced that he would get a private investigator and try to keep the kids away from her. That's
Who
is all
would
she
that?
said.
Who
that
would keep the kids
that
away from her?
that
Oh, his
that
family, Eric's family.
his family, yeah, Eric's family would do that. that was just in talking about divorce that she thought that they would try to keep the kids away from her. And I mean, that's not the same as I'm worried about my kids, who's going to take care
Right.
of them at
Right. It's
all.
just like if I can't have them, you can't either type shit. That seems to be the energy here, you know? Like very competitive type. Um, I don't know. I don't know. I don't know how to pinpoint that just yet. But I mean, throat punching and all kinds of weird shit, you know? I mean, they're redheads. I wouldn't F with them. I'm just saying. Anyways. But I mean, would there be an investigation, y'all, if the family hadn't inquired? I want to know what y'all think. You know, if they wouldn't have pushed the matter, which I mean, of course, that's who you're closest to, right? Your family, or at least, Eric was. But when did it become I think I heard somebody say the other day something about a crime scene. I'm like, there wasn't a crime scene though, not initially. And then for that private investigator to be going to the house even as late as what, last month? It's just strange. It's like you've had all these years. My God. Hawkeyes loves nature. What I've learned is amazing. Thank you for bringing so much light. Things no one talks about, right? And things I shouldn't say for actually. But respect you and your mom, Kay. Keep on exposing what we need to watch out for. Thanks to both you and Donna. Thank you so much, Hawkeyes loves nature. I really appreciate you. I know Donna does too. We're having to play mic tag.
Thank you, Hawkeye.
Thank you. Very sweet. Love your doggy too. So cute. Do y'all think that Lauren's gonna show up? Lauren Quime. Jason, do it.
Oh, Quine.
It's what we do, okay? It's what we do. But do y'all think that there would be, you know, if the family did not push, then would we be here? Would Corey be here? Well, what time do we need to be there, Lamisa? What am I painting now on my walls again? I'm telling you. Crusher, when are you going live? Girl, I live all the time. I'm just kidding. Um, that's kind of what I want to talk to y'all about too. Um, what's today? Friday the 13th, right? Friday the damn 13th. Oh my God. Um, I'm think tomorrow and then Sunday. I think more tomorrow would just be, I don't even know. I don't even know what to talk. There's so many things to talk about, but then I'm like, well, they don't want to talk about that. What do y'all want to talk about? And that'll help me feel more confident or whatever. I won't second guess myself. And I mean, I've been painting, dealing, I was sick a couple days. My my throat hurt really bad, but I feel better since like Tuesday night. Had some family issues to take care of that's still, still going on. But I mean, so I haven't been as dedicated to, you know, analyzing things. But I don't know. Whatever y'all want to talk about. What do you think?
Well, let's see. We could. I'm still. I'm thinking about. Am I picking up on this thing? I was thinking that that maybe we should try to connect some of the things together that we're seeing connect together. You know what I'm saying?
Yeah.
If nothing else, dang, showing a map. I was just looking at how far it is to get from Park City to Urim. Is that the name? That's not the name of that place. Orem.
Orem.
Okay. It's like
So
an
just to
hour and
kind of
15
see
minutes.
the geographical
Yeah.
layout.
I was
Yeah.
actually seeing how long, if one of them was at that thing this morning, how long it would take them to drive to the hearing this afternoon. I was wondering
Yeah.
that if any of them were. Um,
So just kind of
yeah,
talk about the oddities or whatever,
yeah. The fact
just
that
the
we can say
case.
the thing that we can talk about all the damn coincidences that are just clearly nothing but just coincidences.
Yep. Coinky dinks, right? They really stink, them coinky dinks. I remember that I ran across a creator he calls it, instead of conspiracy theorist, he says coincidence theorist. I'm like, I like that. I like that. But yeah, love always truth. You're right. I mean, now that you say that like that, I agree. This is so much like your family. If the Richins didn't push it, Corey would get away with so many crimes. And you just interchange that with Larry and Kay, Lori would have gotten away with so many more crimes, right? I think that's what you're saying. Yeah. So yeah, I guess we'll do a live tomorrow. Just maybe a Corey Richins trial discussion. I don't know. Not trying to be experts here, but
all all
we'll just talk
all
about it.
this all the stuff keeps connecting. So, I mean, we may not know where it's going to end up or where it's going to lead to, but boy, we can see all the connecting pieces.
Yep, for sure. If not, we'll just
And
connect some more. I
and
like to do
also,
like the dual purpose though. I like to analyze through like what, because I'm analyzing Lauren at the same time. So it's like I'm kind of, I know that might aggravate somebody, but or some people, but I don't know. It's just I'm looking at it through that lens, you know.
well, maybe we can review some things, like review some clips from her and how it relates to some clips for some other thing, almost like and I was thinking about like a
An
a
assessment.
cult code word bingo.
Oh yeah. I just don't know how to play it. Look, I can make it in my Canva app. I've done it before, but then I'm like, well, what? How do you do this? How do you keep
Well,
up?
we can't.
How do you know when
You
somebody
don't.
bingos? What do you
You
do?
don't really. You don't really know the way that Jay was doing it. You don't really know. I don't know the real way to play bingo. I just know
Oh,
that we could review some things and find similar things. I'm sure.
we can
Uh,
we can call it Kringo. I'm just thinking Corey
right, and
Richards Bingo.
there's just so many things that just they seem to overlap, and it's like you said. A lot of people don't believe it. I believe that some things can be a coincidence, but
Yeah,
not as
some.
many, not many as we have here.
I
So,
told you, Donna, I live on Cox Road. That's a coincidence from hell. I swear. I'm like, oh my God.
and I
Wow.
live on the Love Road.
There you go. Oh my God. Well, oh, and I was meaning to bring this up just now, but I watched where Justin Riggs, the guy that we've had on before, who talks about, ritual abuse in the church. He has ldsabuse.com. Um, but he's been on to talk about the Bountiful case, the alleged ritualistic abuse case. And he was on Imagination Station or whatever, I think it's called that. He was on another channel, and it's like the second time I've heard him say this, but he says that Park City is highly, um, it's a high ritualistic area. And I find that really fascinating, because I'm like, because I mean, birds of a feather flock together. And about like how Corey was flipping houses, allegedly making money on them. Anyway, that's out for debate. But and how these ritual families or whatever people who are participating in this ritual abuse type stuff, those people that have like the what was that thing called? That mm, it was like a secret room. Um, it was a contractor that he was working on somebody's, an elite Mormon's house or whatever in Utah.
Donnie Osmond. Remember, it was his house at one time.
It was. Oh my God. Well, and yeah, that fascinates me because there's this secret room. It looks like really sick shit could go on there. That's where my imagination went, along with everybody else's too. But anyways, you know what I'm saying. So Corey's in with flipping houses and stuff like that, and how these ritual abusers tend to buy houses from other ritual abusers, and they keep it in the keep in the a ring or whatever. Um, I find that interesting, and the fact that Park City is allegedly, according to Justin Riggs, like a high, I guess, populated, heavily, that's where a lot of ritual abuse spawns from, he says. Um, and then, it makes me think about how whenever after Jody Hildebrandt was arrested, because I was already looking at this angle anyways, because Goel reported about this too. He has, what's the name of his? Oh my gosh. I forgot the name he goes by. Not Goel, but I don't know. I can't think. It's like something abuse, ritual abuse or something like that. Anyways, but he was talking about how a lot of these neighborhoods that he investigated for the Hamlin daughters, David Hamlin's daughters, they were like these kind of circular type neighborhoods where a lot of these ritual abusers would live in the same neighborhood. And it was just, when he was trying to corroborate if what the girls were saying and accusing, so he was like, okay, well, they lived here at this time, and then here's the people they are alleging abused them, and they lived right here. So, he corroborated those type of things. And so I was already looking at Jody Hildebrandt and her fortress and her neighborhood, and it's also kind of circular. I'm not saying that people who live in circular neighborhoods are guilty of anything. I'm just, you know, pointing that out. And then how Lauren, allegedly had to use like John's parents' credit to even go view Jody Hildebrand's house. Anyways, there's a lot to that. I think there's so much. I think we're dealing with the damn mafia. Okay. Okay. The
The
mafia just got
mafia.
nonprofit organizations, is all it is.
Yeah, they say that there are some nonprofit organizations that actually are not crooked, but
Nefarious.
I don't know where they are, and
Yeah, I know. I know. I'm like, prove it. Prove it to me. Because, yeah, I mean, it got to a point. I was researching nonprofit organization because I wanted to look into starting one, right? And then I kind of dabbled in it. Like I was only able to like research it every now and then, I wasn't able to commit everything to it. But all these other people are just like overnight, they're like, boom, 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 I got a nonprofit. And I'm like, whoa, how'd you do that? It's like magic. I'm like, what the hell? What'd you do? Anyway, so I was like, well, damn, I must be stupid, because I'm sitting here like researching all into it and what all it entails and how do you do it. And there's a process, and so it spooked me that bad to where I was like, yeah, nah, something's weird here. Something's weird. But who knows? I wonder if Corey or Eric had any nonprofits. Do anybody know? Joseph
I
Smith
don't
made. Oh,
I don't know if he had any nonprofits, but I do know that they were always busy trying to like be entrepreneurs and start another business. And I don't understand. I mean, I should, I guess, understand that it's like a multi-level marketing
I know what you're talking about.
culture. They just but the bad part about is having a business like that is you depend on your friends and relatives not just to work for you but also be
To
your
buy from you.
customers. Yeah, to
Yeah,
be your customers. And
I think
I
about that
mean,
too. With
and
like the
it's
new skin or whatever the latest MLM is, LuLaRoe or whatever. Yeah, I'm like, what does everybody do? Just like scam their neighbors? And they're like, "Oh no, no, this is good though." And you have Frank Vandersloot who like denies the fact. He will sue you if you say that that Melaleuca Oil Inc. is an MLM. But it is exactly set up like an MLM. He just labeled it something different. I forget what it is, but I'm just like, oh my God, you can't just change definitions. Doesn't mean it's not true. And then Soulshine. Yes. Yeah. Difficult. You know, Joseph Smith made Independence, Missouri the sacred place, and Lori and her minions went there. Actually, it was Lori and Melanie Boudreau Pulowski, and Audrey. Way, way too close to Miles to me. Scary, really. Well, we've even had a theory about that when Jason did. I mean, I don't know. He wondered if after the sacrificial acts or whatever took place, did they bring any part? Anyways, I don't know. Remains. I don't know. I don't know if it's weird, but I mean, yeah, because I've researched like Rod Meldrum. They go there on like this. I think it's called Legacy Tours. Is one of their businesses. They got businesses out there. Yeah, yeah. Okay, so many businesses.
I wanted to tell you about one way that I saw, and it was on that station that we like, the Utah station. It said that Utah, that I think it was Salt Lake City, but it might have been a county. But it said that Utah was the biggest user of to make profit
Porn.
for the OnlyFans. They have
Porn too.
they spend money, but this was talking about OnlyFans, and it said that
Close
not
enough.
only
One
that,
step.
that the OnlyFans, they spent more money on OnlyFans in Utah than any other state, and then also, what was it he said? Oh, there was like 27,000 uh uh what do they call it again? OnlyFans people broadcasting from Utah. 27,000 creators from Utah from having OnlyFans. What the hell are they doing? 27,000 influencers on the OnlyFans.
They're hiding behind the Jesus. They're innocent. I did find a story a while back about a lady who was doing that to make extra money. And I'm like, oh my God. And I mean, the pictures, like, I might have to share that with y'all tomorrow because, well, I don't even want to share the pictures, even though they were on The Sun, had done a story about it, a Mormon woman. And I mean, I'm like, oh my God, lady, you can't, I don't understand that part, where they're like, Jesus, 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 I love Jesus, the Lord, Jesus Christ. Joseph Smith is one true prophet, and da 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 da. That's the one true church, and then they're like OnlyFans, or I don't get it. I don't get. Oh my God, the hypocrisy is crazy. But they're just doing the Lord's work. It's just not the one I worship. I don't know. Anyways, oh yeah, Kelly. Yes, let me share that. Australia isn't a cult tolerant. They kick a bitch out. They said hard pass to L. Ron Hubbard. So he came to the US and insisted his culty business was a religion. Right? Did you know that there is a prophet, or there's a guy named Heber C. Jench who was a prophet for the LDS Church for briefly, and then he went on to um, run Scientology Church for a minute. Heber C. Jench. Heber C. Jench. I can't ever remember it. Say it right. I need to pull some stuff together for him. See what we can find out, because I mean, Scientology and Mormonism is a lot alike, as not in the theology, but kind of. They're newer. I remember when John Dehlin had Leah Remini. I mean, yeah, I used to say it backwards. Rhea Lemony, but Leah Remini on, and I need to find that. And he was saying, that, I don't know. I just remember him making a comment about, oh yeah, while Scientology was making the headlines and everything, he said Mormons were in the background, like hustling, like just hurrying up and building. Anyways, I thought it was funny, but I do get it. And to know that like Leah Remini is associated with Best Friends Animal Society, which is David Levitt, they're associated with that too, which is also associated with the Process Church of the Final Judgment, which is under the Scientology umbrella. It's like the shadow church of Scientology. It's crazy, some crazy shit. And like Jehovah Witnesses, I need to look more into that. As far as like, I have looked into them, and the Freemasonry stuff is so like, I'm like, whoa, how did we not see this? Like, I never put all this stuff together until I went and just, looked back behind the little curtain. And I'm like, son of a bitch. And all these people, it's crazy. Yeah, run. Yeah, I think so too. It's scary to be part of any of those organizations. Yep. And people don't see it. They don't see it as, they see it as like, oh, you're wanting to bring them to Satan, or you're wanting to tear their church down. I've been accused of tearing, trying to bring down a whole damn church. I'm like, well, damn, thank you. That's a compliment. If you think little me can bring down a almost $1 trillion corporation, what the hell am I do with the LDS church? Never mind. Don't
I
ask.
think
I will not answer that.
I was thinking that, you know, some people, when they leave a cult, they go and join up into another cult. I mean, it's just like they have that kind of a,
Like thrive. Yeah.
it's right, yeah, exactly. And that's the weird thing about me. I almost have a phobic thing about it. If somebody's wanting me to get way too happy about anything, and just like like lose
Yeah,
your,
you're like, what do you
lose
want?
yourself.
What?
Music,
Why?
music is about the only thing that I feel like I can lose myself, to the groove and stuff. I'm not losing myself to any other crazy thinking. I'm just not. If it's going to be in my head, I ain't losing myself to get there.
I
Bye.
remember watching you through comments and stuff, before you became a moderator. And I always loved your take on things. And I just knew that I knew you were going through your own process of discovery, and I don't know. It was just interesting to kind of, like I said, you kind of get a sense of people's personalities through years of comments and everything, discussion, so many different things we talk about. And just like whenever I saw that there's a Just Me impersonator on HTC, and I'm like, wait, 5 whatever, and then Just Me is also a 5 whatever, in their name, Just Me, and I'm like, okay, it's not the same person. But then I'd see it again, and I'm like, wait, what was it again? Like I'd sit here and go back and forth. But so there is multiple Just Me's, but it
And
is
I
just
think
me.
I think the Just Me that makes videos is different from the Just Me that we see in our chats, because the Just Me that's in
It
our,
is. She said so
yeah,
earlier.
because she said to me, she asked me something on Facebook. She reached
Yeah.
out to me on Facebook, and I said something, and I said, "Oh, I loved your new video," and she told me, she said, "That's not my video.
What?
That was somebody else's." But we got our own personal Just Me we love.
Yeah. Yes, we do. Just me. There they are. There she is. They are not impersonating. Oh, okay. My bad. We just same names. Okay. Well, that's a big difference. You're right. Yeah, that's a big
Hey,
difference.
look, when I first heard that guy had been caught by those predator trappers or whatever, that
Arctic
Arctic
Fox?
fox,
Yeah.
yes, because I heard them say it, then I couldn't. They were talking, they didn't say the name, and so there's also somebody called Zero Fox,
Mm.
and And I was getting that mixed up at first. And so sometimes people that don't have anything to do with each other can get, you
Get
know,
caught
you
up.
can,
Yeah.
yeah, just on part of the name. And I'm real bad about anytime, and people call other people sis all the time.
Yeah,
It's
I do.
very,
I've done
and
it.
so I'll be just like listening, and somebody will, listen, sis, and I'm like, what did I do now? And even I do that about when people say Donna too. If they're like mad at Donna, that one that Wendy's mother, or they're
Oh,
mad
yeah.
at Reverend Donna, they don't like her.
You're like, damn it.
And then we even have one that comes in here named Donna Lynn P. And I thought she was in. I saw that and I thought, is that somebody trying to imitate me, being Donna Lynn P? Because that has been part of my name for a while, and I guess not. There's just another Donna Lynn P.
Yeah, true that. Well, so what do you, okay, so I'll schedule a live for tomorrow. Um, and then I don't know. I'll have to focus on for Sunday too. Um, I don't know. We'll figure it out. But we'll talk about this case. Maybe both days. Hell, what else we're gonna do? It'll give me a break from the other stuff for right now. Sometimes you gotta step away from it to kind of have it come together. You know, I don't know why he took a phone call, but he did. And so I'm gonna go. He's so rude. Jason.
All right then. Well, then I
Thank
guess it's
you.
just justice for Tylee, JJ, Charles, Tammy,
Joe and
and
Eric.
Joe and Eric, and we'll see y'all tomorrow.
Yes, thank y'all so much. Love always wins.